a lot of persons commented on, and or that we would want to just remind you of as you read through. There were quite a lot of comments on some of the definitions in the bill. I'm not going to take you through those either, but we're just going to focus primarily on those that we thought most, as I said before, most stakeholders seem to have some concern with, and to just remind the members of what essentially had been said and some of the concerns that have been raised, or were raised rather, and some of the recommendations that have been made by the stakeholders themselves. Minister would have indicated as well that, and Ms. Brandon would have shared the ministry's own comments and or proposal or recommendations to the committee, and you'll have the time to review those and treat with them as you see fit. So essentially, this just gives an idea of some of the things that I'm going to take us through. There were questions around, or concerns around, the applicability of the Data Protection Bill, the powers of the Information Commissioner. There were concerns around registration requirements, the need for notification of contravention or breaches by the data controllers, concerns around processing for purposes of journalism. We would have heard over the we'll have heard from the Media Association of Jamaica and the Press Association of Jamaica on that. There were also concerns around the appointment of a data protection officer. Additionally, concerns were raised in relation to fines in the bill, the ability of data controllers to transfer to other jurisdictions. Almost everyone commented on the transition period currently in the bill. Questions were raised around consent by minors, and finally, for the purposes of this presentation, what persons seem to think that there was an exemption, or exemptions, a lot of exemptions apparently for government. The one I'm going to focus on in this presentation is exemption of the government from prosecution. So with respect to the applicability of the Data Protection Bill, members will recall that Clause 3 of the bill says that the bill is applicable to data controllers who are established in Jamaica or anywhere that Jamaican law is applicable, or who are, if they're not established in Jamaica, they use equipment located in Jamaica for the processing of data. And this is not just for transit purposes, it's actually data that is at rest in Jamaica. Established in Jamaica is further defined in the bill as well in Clause 3. It says that a data controller is established in Jamaica if that data controller is ordinarily resident or incorporated under the laws of Jamaica, or maintains a regular practice or carries on an activity through an office, branch, or agency in Jamaica. So that's a context in terms of what the clause currently says. So with respect to the concerns, and we had concerns with respect to this from Digicel, Broadcasting Commission, Jamaica Computer Society, Jamaica Information Technology and Services Alliances, Lawyers Christian Fellowship. The concerns were that the legislation appeared to be restricted, as it was not applicable to foreign entities or service providers that are not established in Jamaica and or would have been processing in Jamaica. Their concerns essentially was therefore that the likes of a Google or a Facebook would not be captured by this legislation. And the recommendations that they made was that the legislation should be applicable to those providers of goods and services, to Jamaicans in Jamaica, irrespective of whether they were physically established here and or processing data here. There were also recommendations that overseas service providers should be prevented from forcing Jamaicans to accept non-Jamaican legal jurisdiction. And I think this particular recommendation came from the Digicel, the contention being that more often than not, the contracts tend to say that the jurisdiction or the choice of law is will be in some other state outside of Jamaica or some other country outside of Jamaica, and more often than not California or New York or wherever. So that was their recommendation in relation to this. So this was essentially the concerns that the entities listed there would have raised in relation to the applicability of the bill. Now you'll see, once you have an opportunity to begin your consideration of the matrix the ministry has put together with support from the Attorney General's chambers on some of the issues, that we have commented on all of these concerns and recommendations. With respect to the powers of the Information Commissioner, members will recall that Clause 4 establishes the Office of the Information Commissioner as a body corporate with the power to monitor our functions, including monitoring the compliance with the Act, providing advice to the Minister, disseminating information to the public, preparing and or directing the preparation of mandatory codes, or encouraging the preparation and dissemination of voluntary codes of practice. Additionally, under Clause 57 and the third schedule, the Commissioner is empowered to enter and search premises, inspect, examine, and test equipment, and inspect and seize documents. So concerns from Lawyers Christian Fellowship, the National Consumers League, Jamaica Aid Support for Life, Press Association of Jamaica, and one individual, Delton Phillips, really the concerns are around what seemed to be a lack of accountability and oversight. It didn't appear in their estimation that there was anyone that the commissioner or the office would be directly reporting to. There were also concerns around what seemed to be the wide powers of the OIC to enter and search premises. I should add here that the members will also recall that the NIDS project had raised some concerns with the ability of the Information Commissioner, or the power of the Information Commissioner in relation to their own database that would have been established under that NERA Act. So the recommendations in relation to the Information Commissioner was that, from our stakeholders, was that the Information Commissioner needed to be subject to parliamentary oversight or some other oversight, whether it's a body or a board or of sorts, and that the Commissioner should be required to provide details of what it is that what is to be searched and seized where applicable, and in the case of ministries, departments, and agencies, justification for such search and seizure should be presented. There were also, with respect to the powers of the Commissioner, recommendations in relation to how he or she could enter premises, and the fact that we know within the legislation now warrants are required, but the warrant, by virtue of the legislation as it exists now, the bill rather, would be obtained from a parish court, and there were recommendations from our stakeholders that needed to go a little bit higher, and recommendations that you should go to a Supreme Court judge rather than a parish judge. With respect to registration requirements, members will recall that clauses 15, 16, and 17, I'm going to get to 17, provide that data controllers are prohibited from processing personal data unless registration particulars are included in a register that is to be maintained by the Office of the Information Commissioner. And the particulars that would be included in the register include contact information about the data controller and the data protection officer that is to be appointed, description of the personal data that is being processed, the purpose for the processing, any recipient to whom the data controller intends to or may wish to disclose the data, particulars of any territory to which the data controller directly or indirectly transfers or intends or may wish to transfer data. Clause 17 requires data controllers to pay an annual fee to maintain its or their legal or natural persons registration particulars in the register. So the concerns with respect to this, coming from Jamaican Bar Association, JCS, Jamaica Chamber of Commerce, Slash Roots, Credit Info, and one individual, Shaista Pert, essentially was that the requirement for registration was considered to be overregulation. There were concerns about every single possible data controller being required, which could include your churches, your NGOs, your hairdresser, your mechanic, being required to register. Requirement for MSMEs, smaller, to register and pay an annual fee was considered to be onerous and anti-business. Concerns were raised around what the fee would be used to do, and how the fees were to be calculated, how this annual fee would be calculated and applied across with respect to data controllers. And so the recommendations that the stakeholders made was that we should consider a de minimis threshold for imposition of obligations for small organizations. So either MSMEs or NGOs should be excluded from the requirement to register. We should ensure that the revenue from fees is used to fund the OIC, and that fee should be set depending on the size and the turnover of an organization. So even if everyone is required to register, then that registration fee would be dependent, the argument is, on the size of the organization and the turnover of the organization. So these are some of the recommendations the committee would have received from the stakeholders. With respect to notification of contravention and breach, Clause 21 of the bill currently requires data controllers to report without undue delay any contravention of the data protection standards. And members will recall that the bill has 8 data protection standards. And of course, contravention of that and security breaches. The reports that they're required to file to the OIC should address the facts surrounding the contravention or breach, the nature of the contravention or breach, including the number of data subjects and type of data concerned, mitigation measures taken or proposed to be taken, and the consequences of the breach. And additionally, Clause 21 requires that the data subject be notified where the breach is likely to affect them. So the concerns in relation to this particular clause came from Credit Info, Digicel, ITIC, and the Office of the Director of Public Prosecution. Concerns were raised in relation to the use of the word likely. It was believed that it imposed an unreasonable obligation on data controllers, and I'll just go back a little bit to say at the bottom of this particular slide, with respect to the data subject, it says they're required to notify the data subject where it is the breach is likely to affect the data subject. So there were concerns around the use of the word likely in that regard. There was an argument that this was almost kind of self-incriminatory because you're reporting on your own non-compliance with the data protection standards and or security breaches. And there were other persons who felt that there's a possibility for an undue amount of reporting, because if every single security breach that occurs you have to report on, then that could be onerous. So the recommendations in relation to this particular clause was that the committee should consider requiring only substantial breaches or those that represent a real risk to be notified, require other breaches to be reported periodically throughout the year, whether it's every 2 or 3 months, and that consideration could be given to adopting a breach notification regime that incorporates a risk of harm analysis. The committee would have heard from both the Press Association of Jamaica and the Media Association of Jamaica in relation to the processing for purpose of journalism. Members are reminded that Clause 37, which treats with processing, states that personal data processed only for special purposes, that is, journalism, literary, and artistic purpose, are exempt from all the things that we see here. All the data protection standards, with the exception of Standard 7, and Standard 7 treats with technical and organization measures to prevent unauthorized and unlawful processing. Special purposes processing would be exempt from Clause 6, which is the right of access to personal data, Clause 10, which is the right to prevent processing likely to cause damage or distress, Clause 12, which is the rights in relation to automated processing, and Clause 13, subclause 3 and 4, which treat with rectification of inaccuracies. The exemption for special purposes is allowed if the processing is with a view to publishing any journalistic, literary, or artistic material. The publication would be in the public interest, having regard to the public interest in freedom of expression, and in all the circumstances, compliance with the provision is incompatible with the special purposes. So, jump into Clause 52 because it's kind of related. If it appears to the Commissioner that personal data are not being processed for special purposes, that is for journalistic, literary, or artistic material, then the Commissioner may make a determination in writing to that effect. So the concerns that were raised, and mainly from the PAJ, is that concerns are that allegation that publication is not only for the purpose of journalism could stifle the practice of journalism. The Commissioner was essentially being placed in a superintending role to determine whether publication is in the public interest. And generally, their recommendation was that blanket exemption from the legislation should be given for the practice of journalism. Appointment of data protection officers. Currently, Clause 20 of the bill requires data controllers to appoint an appropriately qualified person as a data protection officer. The role of the data protection officer is to monitor in an independent manner the data controller's compliance with the data protection bill and ensure that any contravention is addressed, to consult with the Commissioner to resolve any doubts regarding the provisions of the data protection bill, to assist the data subject in the exercise of his or her rights, and to notify the Commissioner if he or she is not satisfied that the data controller has rectified contraventions that the data protection officer has brought to the data controller's attention. The concerns from stakeholders, and these stakeholders included the Jamaica Computer Society, JITSA, Jamaican Bar Association, Jamaica Bankers Association, was that there's likely self-incrimination, again, an inherent conflict of interest, because potentially someone within, an employee within the organization would be the one that would be going to the Office of the Information Commissioner to report on the company's or the data controller's lack of compliance. Questions were raised around the independence of that data protection officer, considering that he or she could likely be an employee of the organization. There were also concerns around whether or not dearth of qualified persons, considering that this is essentially a very new regime for us in Jamaica, that the need to appoint a data protection officer would essentially be an additional cost, particularly to MSMEs, and just general concerns that this might be over-regulation if every single data controller had to appoint a data protection officer. So the recommendations from the stakeholders included that requirement should be limited to processors of, it says processors, but essentially it's data controllers who process sensitive or other data requiring internal control, that an obligation to report to the OIC be replaced with reporting to the organization's board, and that we impose that the requirement for a data protection officer be imposed on larger firms that rather than MSMEs. With respect to fines, fines are spread across the bill currently. So in clauses 16, the ones I'm going to focus on are the ones that stakeholders would have commented on. Clauses 16, 18, 19, 21, and 70. Fines are ranged throughout the bill from 500,000 to 5 million, and the terms of imprisonment range, depending on the offense, from 2 to 10 years. We have in the bill currently one particular, that's clause 70, one particular offense or sanction where, when committed by a body corporate, would lead to a fine that not exceeding 10% of the body corporate's annual gross income. And of course, the concerns around that, the fines, were that they were onerous. The 10% sanction would be in addition to fines that were imposed on specific provisions, for example, a clause 16 offense or a clause 18 offense, and so on. So there was recommendation that the fines and the periods of imprisonment should be lowered, that the 10% sanction should be reserved for cases where the breach was profit motivated, and that a precise sum rather than a percentage should be stated, as in the case of other legislation, and I suppose as is the case within the bill itself. So moving to transfer to other jurisdictions, members will recall that clause 31, which is standard 8, data protection standard 8, says that data is not to be transferred to another jurisdiction unless that jurisdiction to which it is being transferred ensures an adequate level of protection. And adequacy is determined by a list of factors including the nature of the personal data, the state or territory or final destination of the data, the purposes and period for which the data are intended to be processed, and the security measures that that will be taken in relation to the data when it gets to that destination. So the concerns around transfer to other jurisdictions, concerns were raised by the Jamaica Bankers Association, Digicel, the U.S. Chamber of Commerce, and ITIC, and essentially their concerns were that no guidance was provided on what is adequate protection and how this would be determined. There are concerns that if member states within the CARICOM do not now have a data protection bill, then essentially what would happen is that we couldn't transfer data to them as well, either. The legal ground specified for the transfer of data outside the jurisdiction was said to be ambiguous, and generally a comment that, you know, adequacy is not the best way to determine transfer. We need to be looking at other mechanisms. So the recommendation was that we should consider forward-thinking mechanisms such as contractual clauses, global corporate standards, certification, and privacy marks, that we should facilitate international intra-company transfers between members of the same group of company, you know, that might be located here, but then located in Barbados and located somewhere else, and transfers in that respect should be allowed, and that we should specify a predetermined list of states that would meet that adequacy requirement. Essentially, one stakeholder in particular was calling for that list to be in the bill as of now, but failing that certainly within a short period of time. With respect to the transition period, and I think members will recall this conversation, the bill now requires that data controllers be compliant within 1 year from the date of the commencement of the act. So whenever that date is, they would have 1 year to be ready. And of course, the concerns from almost all the stakeholders was that the period was too short, time would be required to develop subsidiary legislation, and of course within their own organizations to implement the technical and operational changes that would be needed to be able to be compliant with the legislation. And so the recommendations coming from our stakeholders was that transition period should be extended to 2 or 3 years, or that we could apply a phased approach to the implementation of the legislation. Consent by minors. So clauses 2, 5, 23, 24 speak to consent generally, but we're focusing on consent by minors here. What clause 5 currently says is that where an individual is a minor, his or her rights under Part 2 of the Data Protection Bill, and Part 2 of the bill treats with the data subject's rights generally. So those rights may be exercised by a parent or a legal guardian where the law recognizes the capacity of the minor to act. And minor is defined in Clause 2 of the bill as an individual under the age of 18 years. So comments came from Digicel, Jamaica Aid Support, Jamaica Computer Society, and JITSA on this particular issue of consent by minors. The concern was that the age limit was out of step with the consent policy of many of the online social media platforms to which minors subscribe. Providers have set the age of minority to be within the age range of 13 to 16 years. And Jamaica Aid Support in particular pointed out that a minor is defined as a person under the age of 18 in some pieces of legislation, 16 in others, and in some legislation, both 16 and 18 in different sections. So additionally, concerns were raised, and I think this was at Jamaica Aid Support, that the definition of a minor will prove problematic, as it means that the parent or parents of a 17-year-old who access services at a health facility without their knowledge and or consent could demand that the facility produce that minor's health records without that child's consent, because of course they would be acting on it well. The recommendations in relation to this particular issue from our stakeholders was that the age of consent should be revisited. Consideration should be given to setting the age at 13, and that data controllers be required to take all reasonable steps to ensure that consent is given or authorized by the parent or guardian where the data subject is a minor. So while some persons were, we could go to 13 and allow minors to essentially engage some of these on their own and provide their own consent in relation to the use of their data. Others felt that data controllers must obtain the authorization from parents or guardian where that individual is a minor. I think this is the last. Yes. So with respect to exemption of the government from prosecution, Clause 74, subclause 3, excludes public authorities from liability to prosecution under the Data Protection Bill. Concerns were raised by the Jamaican Bar Association, the Jamaica Computer Society, the Lawyers Christian Fellowship in relation to this. Their concern was that the government, as the largest data controller and consequently with the greatest potential for non-compliance with the Data Protection Bill, is exempting itself from prosecution under the bill. Felt that it was grossly unfair given that there are some public bodies that compete in ways similar to private bodies, but yet they would be protected in a sense from prosecution, but the private body would not be. And so the recommendation in relation to this was that section 4.3 of the bill should be deleted. And I think that brings me to the end.
Thank you very much, Ms. Murray, for that overview, that refresher. I don't know if there are any particular questions that members have on that presentation that they wanted to ask. Any comments right now?
So what you have just gone through is what was sent to us earlier?
And more. So as I indicated, that was just some of the comments But what the matrix that would have been circulated this afternoon seeks to address every single concern and or recommendation made. So what you will see, members, is a matrix that looks at, well, one column treats, as Minister Williams pointed out, treats with our research globally to see how other jurisdictions treat with that particular issue. And then you will see what is the ministry's own recommendation to the committee for consideration. And we've done that for all the clauses that have been commented on, so from clause 2 straight through to the end of the bill. What you don't have, Minister, and I will just say this to the committee, just for transparency purposes, there are some general comments that were made that weren't, and you'll see that in the matrices from the Parliament, there are some general comments that were made that were not aligned to any particular clause. So there were just comments and recommendations. The ministry has not compiled their response to that, completed the compilation of its response to that as yet. So what you have before you, at least electronically, would be our comments on just the clauses.
Can you go back to the consent, age of consent from it? Just flip back. And maybe this is for legal reform. Would there be any issue of lack of consistency in terms of other pieces of legislation if we adopted the age of 13 in this particular case? And whether it would have implications for other pieces of legislation?
In response, so Minister would have indicated that the matrix that you'll see with the recommendations that the ministry is proposing would have included some comments from AGC. So we would have pulled out some issues and written to the Attorney General's chambers, asking them specifically to opine on these, and this is one of them. So, and they have provided their comments on this in particular. So I think when the members see the full matrix,
can summarize, or can they just indicate what their view is on this particular matter?
The thrust of it is that it's a policy decision that the committee will have to determine. The Jamaica Aid Support, we think, correctly stated the legal position insofar as different pieces of legislation prescribe. There's a set age of consent, and that piece of legislation indicates that other legislation can prescribe different ages within those particular acts. And so you will find that different ages apply across different pieces of legislation. So what the committee will have to determine is what is the appropriate age that you think is appropriate for the data protection scheme. We also highlighted the fact that I think in the European Union experience, across the European Union, the age varies within the European Union itself. So some countries have it at 18, some have at 15, some have at 16. And that's descriptive of the fact that different considerations apply depending on the society that you're in. But there is also a sort of carve-out for what applies to access to online services or services which are educational in nature, and how some of those legislation deal with it is to have that as a carve-out, and some countries have a lower age if you're giving consent to an online educational service, but a higher age of consent, the usual 18, for any other type of consent that you're giving for data related issues. So I think that's the...
So in essence, the decision would be up to us to recommend to Parliament, and you don't foresee an issue with other pieces of legislation which would have a different age, in essence.
Right. At the moment, and in light of the research that we did, no legal conflict as such.
Okay.
In large part because all pieces of legislation, if they have in mind that consent may vary, will so prescribe. But the general principle is 18, and then if for whatever reason that particular area of law might benefit from having a lower age of consent, that particular legislation will so dictate. And there may well be some of those arguments were made by the stakeholders in favor of having either a lower age or a lower age for specific purposes. But that is something that the committee will have to deliberate on.
Could you go to the transition period, where you had raised that? Okay. And the phased approach is the thinking, I think, go to the next slide. You had something about... the
last one is phased approach.
No, it's just one slide you had on that. About was there consideration in the recommendation about, I don't know if it was here, about the size of the company. Was it in here or somewhere else? And how you would treat, and how you would define what a small, medium-sized enterprise would be versus a larger entity, an entrepreneur who is the sole proprietor versus, a business with 2 or 3 people. Or would you look at revenues? What would be the criteria to determine the extent or the implication of phasing, so to speak?
If I might, through you, Chair, to the member. So the issues was not around the transition period, but this clause, clause 20, with respect to the data protection officer, and with respect to the registration requirements. So that was where there was a belief that, and I can go to it, that essentially, NGOs, MSMEs shouldn't be required to register to process. None of the stakeholders gave any indication as to how they would see this, phased and or demarcation being made. They spoke about large as opposed to small. In the context of the government, I think the only, certainly as far as I know, the only policy that seeks to define who an MSME is the MSME policy. And they kind of have a demarcation as to who is small and who is large in the context of whether employee or revenue. But the stakeholders didn't indicate, and the members will see the ministry's comments generally on registration.
Madam Chair, yes. With respect to Member Robinson's observation as it relates to what will determine the size of a business, as it relates to whether it is small or big, I think maybe you could look at the system that is used in the registration for general consumption tax, because there is a threshold in terms of determining size of business, where business that annual sales is under 10 million, that kind of a thing, similar to, maybe you could look at that as a... the other point I want to make is in relation to the recommendation for exemption, for government exemption from prosecution. Well, you consider that. I don't know if you take into consideration the decision that was made by the court in relation to NIDS. The decision that was taken as it relates to the government's collecting information and so from persons as it relates to NIDS. I'm saying that I don't know if you would take that into consideration when you look at the whole matter of whether or not the government could be liable for prosecution in collecting data and so on. I don't know if you look at the entire reading from the court in that instance, in terms of making your overall determination whether you will accept that the government should be exempt from prosecution.
Right. We have been considering the NIDS judgment and its potential implications for the legislation. As it's in the nature of these things, it's an ongoing process of consideration. The judgment is pretty lengthy and deals with several different issues. At the moment, we can say that there are two issues which may have some implications for how the committee goes about aspects of the bill. One is in relation to the extraterritorial application, whether the burdens that are placed on persons in Jamaica processing information on Jamaicans will apply to persons outside of Jamaica doing the same thing. And the other is in relation to the fines which apply in the legislation. And I said because one of the concerns expressed in the judgment was that where data is being processed by others, in the context of the judgment it was the state, but we think the principle applies generally, that given the nature of data and how easy it is to, once it's gone, it's effectively gone forever, once somebody takes it or uses it in an unlawful way, that the fines have to be sufficiently severe to deter individuals and especially companies that seek to profit from the data of others from doing so. So I think considering the fines on the legislation, the committee should satisfy itself that those are sufficiently high to deter anyone from using others' information unlawfully. In relation to the specific point that you raised, we would have to give that some further consideration. But as no advised, I don't think that anything in the judgment should pose a difficulty in relation to the question of whether the state should be subject to prosecution for breaches. And criminal sanction is one thing, but the state is a unique creature in the scheme of things. And outside of prosecution, there are other methods that can be used to redress people's rights when it's committed by agents of the state. But that's something we will give some further consideration to.
I think that is very important in the scheme of things, given what came out of that decision, that you give it very, very thorough thought and consideration.
But I should also add that the context of the NIDS judgment is very different to what this legislation seeks to deal with. So the context of NIDS was the government, as the court found, compulsorily taking information from citizens. This legislation doesn't do that. What this legislation purports to do is to provide a framework within which people's data rights can be protected through the legislation. So it's not taking anything. It's trying to give something in the form of set out specifically specifically enumerated data protection, data rights, and means of redress if those rights are infringed.
Right, but so
I have another set of questions. Under the, you can go to the slide on the exemption for journalism. And just to ensure we are on the same page about a distinction between the practice of journalism to protect the freedom of expression versus a company that may be involved in journalistic pursuits. So let me try to give an example and just pull in one. Let's say TVJ, involved in a whole set of activities, journalism, broadcasting, all of that. TVJ would not be exempt from, well, should not be exempt from the legislation, but someone who is practicing journalism, collecting information, which may be confidential, sensitive, etc., that element is what we're saying should be exempt. Is that what we're saying?
So, in response, to the extent that, using the example you've used, TVJ is in the business of journalism, then that data that it collects, personal data, and or sensitive personal data that it collects in relation to that aspect of their business would be exempt in this way. But there are other arms.
Right,
so for example, TVJ in the context of an employer with employees would still have to comply with the legislation in relation to its employer-employee relationship. So the data that it has on its employees, it would have to comply in this way. So we're talking about the business of journalism.
And I think you just need to make it clear so that the company doesn't believe that, because I'm in journalism and because of how technology has changed as well. What used to be considered a traditional journalist is no longer. So when Robert tweets, he might consider himself a journalist because he's tweeted, right? You're a journalist, right? But no, it's a serious point, though. Although I'm poking fun, because what's a blogger? Is a blogger a journalist? Could be. You share information. So I just, in terms of how we define it in the news space, we have to think about how the role has evolved.
Ms. Murray, just a quick question. I don't remember that there was a definition of journalism in the Act, right?
When we raise the whole thing about bloggers and so on, it triggers a reaction in me that we need to look back at it, because there's no definition.
Through the chair, to support what Julian said, but it's more a query than a question. Have you considered, so you have and I won't use a name, so you have a corporation that practices journalism, but that corporation has within that same space entities that also provide corporate services. Let's say they provide social media marketing services. Is there any contemplation in the law? Because if you are practicing journalism and you're collecting personal data from members of the public and collecting troves of information to assist you in your journalism, you could also use that data to assist you in your other business of, let's say, social media marketing. Does the law contemplate making it very clear that though we are seeking to protect freedom of expression, the entity that is doing the journalism work cannot use that data in other associated businesses?
No, so they wouldn't be allowed by the law as it is now written, the bill itself rather, to do that. Because what is protected is journalism, literary, and artistic material. So to the extent that you collect personal data and you might use it for a piece, whether it's something that you're blogging or a news, an article in a newspaper or whatever, then that would fall within the context of the clause and the exemptions that we're speaking about. But once you begin to use that information, or let me not say information, that personal data for something other than journalism, artistic or literary material, then you'd be running afoul of the legislation and you would actually be in breach. And it is in the, yes, because what it says is that it's spelled out. It's there in the sense that so clause 37 says personal data which are processed only for the special purposes are exempt. So, and it goes on to say what special purposes are, and that is journalistic, literary, or artistic material. The publication of that. So if you are using the information, the personal data, to do anything other than that, then you would not have been processing only for special purposes, and then you would be running afoul of the legislation. And then in clause.
Can I clarify the rationale behind my statement? So, when I was in another place, there was a robust discussion in this house on this bill, and I saw persons who are interested in this clause doing massive media campaigns about the bill, seeking to influence how the public views the clauses in the bill. And it's a serious thing, Julian. So if I'm a media journalist and there's a law that comes up that is going to impact my profession, and I then move from being just a journalist to being a marketing advocate for my own profession, how do you, and I just would love if you to explain to me, how do you make the distinction between, let's say, the ads that were run by the Media Association and whoever else use, I don't know if you understand what I'm asking. So when a journalist is a journalist but is advocating on their own behalf, and they may use information as a journalist to target, to lobby, using data that they get on their customers.
As a journalist.
So you sell newspapers, so you have a list of subscribers to your customers. But then you move from being just a journalist to an advocate. How does that work?
Sorry, I would think before you answer, I would assume, perhaps wrongly, but that under 37 subsection 3A is relevant to the publication in question. Gives you some amount of cover that it's really just when people are pursuing journalistic endeavors. I think the weakness, as Mr. Williams would have pointed out, is really just a lack of definition for journalists and journalism. I'm not sure how you're going to define it, but I think that is the weakness that we'll have to attempt to address.
The reason I ask the question is that if in the practice of journalism I have to distribute my content to a list of subscribers who have given me their data as subscribers, how do you move from a subscription relationship to an advocacy relationship? Because the journalists would argue that they're still functioning within the remit of journalism by
Well, you can't if it's...
But member, if you would have gotten data from your subscribers, then they would have given you consent on that data. Huh? Member Cuthbert, can you use your mic, please?
But in response, there are maybe two areas I wanted to direct the members to in responding to that particular concern. So there is the right that is contemplated under 10. No, my apologies. 1 second. Direct marketing. Clause 11, which treats with the right to prevent the processing for purposes of direct marketing. So it says that no, an individual is entitled at any time by notice given orally or in writing to a data controller, which would be what your media house is, to require the data controller within a period that is reasonable in the circumstances to cease or not to begin processing for the purposes of direct marketing any personal data in respect of which the individual is the data subject. And it defines data direct marketing as being communication by whatever means of any advertising or marketing material that is directed to that particular individual. So there is that general right. So the data subject, the citizen, could say, please desist from sending me these things, one. But additionally, if we turn to standard, this is clause 25, and that's the second data protection standard. It says that the second standard is that personal data shall be obtained only for one or more specified and lawful purposes and shall not be further processed in any manner incompatible with those purposes. So essentially what that is saying is if you tell me that you are collecting my personal data, we're not talking about general information here, and I want us to make a distinction. We're talking about personal data and personal sensitive data. So that if you tell me that you're collecting my data for a specific purpose, you cannot then use my personal data or sensitive personal data to do something else, because I would have likely consented to a particular purpose, and then you cannot then go behind my back and then use my data for another purpose. So in answer to your question, Member Morgan, if it is that the data was collected or the personal information was being used for journalistic purposes, and then the person from whom the information, the personal data is taken, was not advised that he would be getting advertisements and marketing and further things, and you're going to be using for that, essentially the data controller would have been in breach of the second standard.
I mean, I think the word incompatible spelled it all out to explain exactly what he was trying to convey.
And remember as well, members, that the data controller is the one who decides what is the purpose that they want the data for, right? So it's not anyone who makes that decision for them. So the law is saying if you say you want it for 1, 2, 3, 4, 5, 10, or 20 different uses, and they look at it and you're using it for something else, then you're in breach of the law.
Since you have up the Information Commissioner, I think one of the recommendations we made, the person is appointed, is it for a 5-year term? I don't know why I thought we had made a recommendation for, or was there? I'm just trying to remember. I could be wrong. I don't know why I thought we said maybe 7, that it would cut across. No? Okay, all right, sorry. All right.
Remember, it's 5, but no more than 2 terms.
It was 5?
5. But
yeah,
you cannot serve more than 2 terms.
Yeah, I think just so it wouldn't necessarily always coincide with the electoral cycle. I wanted 7, but it's something we can look at. I don't think it should absolutely coincide with the electoral cycle, because I think it the person maybe it makes them less independent if it coincides exactly with the electoral cycle.
Okay, except that it won't always coincide, right? Because
I know, because the term,
you could have done it in the middle of the term, and
but in putting it, I don't think we should put it exactly at 5. That was my recollection, but. And again, can you remind me of the appointment process for the Information Commissioner again?
So the first schedule, page, let me not refer to the page, I'm not sure how many people have their bill. So it speaks about the appointment by the Governor General after consultation with the Prime Minister and the Leader of the Opposition.
And we're going to get the hard copy of your presentation plus the one that was emailed. My printer ink will finish at 125 pages, so I ask Parliament to print it for us, please. And we can't really read it on the computer.
Duly noted, member. Yeah, duly noted. But that shouldn't prevent you from starting to read, because you have the soft copy.
I can't read that on my computer, and you need to mark it up. But we would need it. When are you thinking of the next meeting?
The next meeting is scheduled for the 29th, the 24th. Wednesday the 24th at 2 p.m. And then after that it would be the 31st of July at a similar, at 2 o'clock as well, 2 p.m. as well.
Is there any way we can get that maybe at Parliament and the Senate to get that before, so we can make our little markings and read through properly?
No, absolutely.
Is that possible?
You will have it before, way before that meeting. Because you have it now in soft copy. We'll just get it printed in hard copy and come to you.
So you intend to conclude by the end of July?
That is the plan.
Okay.
You know, those are the meeting dates that we have right now.
24th and 31st. So 24th, same 2 o'clock, and then 31st, 2 o'clock?
Right, yes.
I know she's not going to have a quorum on the 31st, it's the day before Emancipation Day.
So let me ask if there's any other business.
There's no way she will get a quorum.
All right.
Emancipation Day is the first.
I want to thank the members again and look forward to seeing you on the 24th at 2 p.m. Thank you to the staff. Thank you to all the technical people. See you on the 24th.
That's the day of your father's lecture too.
Yeah.
In the afternoon.
Yeah.
It's Wednesday, July 10. This is the news on PBCJ. I am Simone Absalom. Minister without portfolio in the Ministry of Economic Growth and Job Creation, Senator Pernell Charles Jr., says more enforcement is needed to protect the nation's water assets from violations. Senator Charles Jr., who was speaking with stakeholders at the Manchester Municipal